Welcome to Civ Pro Episode 1 of the Zec Support Legal Study Series. In this series, we'll explore civil procedure, what it is, why it matters, and how it plays out in real cases. We will break down the rules and structures that shape our legal system. We'll also explore the foundations of civil action, including its historical roots, its role in the justice system, and why courts operate the way they do. Let's start with the basics. Civil procedure is the set of rules that governs how lawsuits unfold in court. Think of it as the blueprint that ensures fairness, structure, and efficiency in resolving legal disputes. Unlike criminal law, which deals with offenses against society, civil cases involve private parties, individuals, businesses, or even government entities seeking to enforce rights or settle disputes. At its core, civil procedure serves two major purposes: resolving conflicts and shaping behavior. Courts don't just decide who wins or loses a case. They also influence how people act in society. If businesses know they could be sued for harmful practices, they're more likely to follow the rules. If individuals believe the court system is fair, they're more likely to accept its decisions, even when they lose. One of the biggest features of the U.S. legal system is the adversarial model. This means that legal disputes play out like a structured contest between two parties, with a judge acting as a referee. The idea is that when both sides present their strongest arguments, the truth is more likely to emerge. But the system does have its critics. Some argue it favors those with better lawyers rather than those with the strongest case. Courts also rely on two main types of law: substantive law and procedural law. Substantive law defines rights and responsibilities. Think of contract rules, personal injury laws, and property disputes. Procedural law, on the other hand, lays out the steps needed to enforce those rights. It dictates things like when a lawsuit must be filed, how evidence is presented, and what rules judges must follow when making decisions. But here's where it gets tricky. The line between substantive and procedural law isn't always clear. Take statutes of limitations, for example. They dictate how long you have to file a lawsuit. While that might seem procedural, these deadlines can actually shape whether a person can enforce their rights at all, making them almost as impactful as substantive laws. Now let's talk about how a civil lawsuit actually begins. It all starts when one party, the plaintiff, decides to sue another party, the defendant. But before heading to court, the plaintiff must consider three key questions. 1. Is legal relief available? Not every grievance is legally actionable. Just because you feel wronged doesn't mean the courts can step in. 2. What are the chances of winning? Evidence, witnesses, and legal precedent all play a role in whether a lawsuit is worth pursuing. And 3. Is it worth the cost? Lawsuits are expensive. Unlike some legal systems where the loser pays the winner's legal fees, known as the English rule, the U.S. generally follows the American rule, where each side pays their own attorney fees unless a law says otherwise. Once these considerations are made, the plaintiff must decide which court has the authority or jurisdiction to hear the case. Courts can be divided by geography, type of law, or even the amount of money in dispute. For example, imagine a person named Anna is injured in a car accident and wants to sue the driver's employer for negligence. She has to figure out whether to file her lawsuit in state or federal court, which depends on factors like where the accident happened and whether federal laws are involved. But let's talk about jurisdiction, a fancy legal term that simply means a court's authority to hear a case. There are two major types of jurisdiction every case must satisfy. 1. Subject matter jurisdiction. The court must have the legal authority to decide the type of case being brought. Or 2. Personal jurisdiction. The court must have power over the defendant being sued. In the federal court system, jurisdiction is strictly limited. Federal district courts hear two main types of cases: federal question cases, where the lawsuit is based on federal law, or diversity cases, where the parties are from different states, or one is from a foreign country, and the amount in controversy exceeds $75,000. That means if it's $75,001, it can be considered a diversity case. Keep in mind that state courts have a very broad jurisdiction. They can hear almost any kind of case unless a law specifically says otherwise. Personal jurisdiction determines whether a court can make a defendant show up and participate in a case. Traditionally, courts only had power over people who were physically in the state, but as society became more mobile, these rules expanded. Today, a court can assert personal jurisdiction over a defendant if the defendant lives in the state, the defendant committed a harmful act in the state, the defendant has enough connections with the state to make a lawsuit there fair. Another key legal concept is venue. Essentially, which specific courthouse within a state or federal system should hear the case. Venue laws prevent plaintiffs from picking inconvenient locations just to make life difficult for defendants. Instead, cases usually must be filed where the defendant lives or where the events leading to the lawsuit took place. But what happens if a plaintiff tricks a defendant into showing up in court to be served with legal papers? Well, that brings us to a fascinating case, Tickle v. Barton. Here's what happened. A lawyer representing a plaintiff called Barton, a resident of another state, invited him to a banquet. But it wasn't just any invitation. It was a trap. When Barton showed up at the banquet, a sheriff was waiting to hand him legal papers. Barton argued that he was tricked into entering the court's jurisdiction and challenged the validity of the lawsuit. The court agreed, ruling that fraudulent service of process is invalid. In other words, you can't trick someone into showing up just to serve them papers. The law requires that service of process be done in a way that reasonably ensures the defendant knows about the lawsuit, not through deception. So how does a lawsuit actually start? By serving process. That means delivering a summons, which tells the defendant they're being sued, and a complaint, which explains what the lawsuit is about. Typically, process is served in person by a sheriff or a professional process server. If the defendant is out of state, alternatives like certified mail or service through an agent might be allowed. Courts have repeatedly emphasized that the method of service must be reasonably calculated to inform the defendant. So let's talk about the crucial first steps in getting a lawsuit off the ground. What happens after a case is filed? How does it move forward? Pleadings, the initial court documents that frame the case. The complaint is the plaintiff's official statement of their claim. It must provide enough details to let the defendant understand the allegations and prepare a defense. But how much detail is required? That depends on the legal system. Some systems demand highly detailed complaints, listing specific acts of negligence, injuries, and legal claims. Others allow notice pleading, where a simple claim like, the defendant negligently drove a car into the plaintiff, is enough to move forward. If the complaint is vague, the defense might file a motion to dismiss, arguing that the case doesn't provide enough legal grounds to proceed. If the case survives dismissal, the defendant files an answer, where they admit or deny each allegation and may raise affirmative defenses, like arguing that the plaintiff was also negligent. Now let's talk about pretrial discovery, the phase where both sides gather evidence. This stage is crucial because most cases never make it to trial. They settle based on what's uncovered during discovery. Discovery tools include depositions, where lawyers question witnesses under oath, recording their statements for trial, interrogatories, written questions that must be answered under oath, requests for production, demands for documents like medical records or emails, requests for admission, asking a party to admit or deny certain facts to narrow the issues for trial. One of the most controversial uses of discovery is the fishing expedition, where a plaintiff files a vague complaint just to force the other side to reveal information that might help build a stronger case. To prevent abuse, courts can impose sanctions on parties who file baseless claims. Discovery also plays a key role in summary judgment, a process where one side argues that there is no need for trial because the evidence overwhelmingly supports their case. If the judge agrees, the case is decided without ever reaching a jury. But if summary judgment is denied, the case heads to trial preparation. First, it gets scheduled, oftentimes months or even years later, due to crowded court calendars. Then comes jury selection. In most civil cases, either party can demand a jury, though some cases, like those seeking injunctions, are decided by a judge alone. Lawyers can remove jurors for cause like biases, Lawyers can remove jurors for cause, like bias, or use a limited number of peremptory challenges to excuse jurors without giving a reason. The trial itself follows a structured process. First, there's opening statements. Each side previews their arguments for the jury. Then, the plaintiff's case. The witnesses testify and evidence is presented. The defense cross-examines. The defense's case. The defense presents its witnesses and the plaintiff cross-examines. The closing arguments. Each side sums up its case for the jury. And jury instructions. The judge explains the law that the jury must apply. The jury then deliberates and returns a verdict, either for the plaintiff with a damages award or for the defendant. But that's not the end. After the verdict, the losing party may file post-trial motions, like a motion for a new trial, arguing that errors in the case warrant a do-over, or a motion for judgment notwithstanding the verdict, asking the judge to override the jury's decision. If those fail, the losing party can appeal, but appeals aren't a second trial. The appellate court reviews whether legal errors were made, not whether they agree with the jury's decision. Even after a case is won, the battle may not be over. The winning party still has to enforce the judgment, which can mean garnishing wages or seizing assets if the losing party refuses to pay. And once the case is fully resolved, then it's res judicata, or Latin for a thing decided. That means the issue can't be relitigated in a new lawsuit. Why does this matter? Because civil procedure isn't just about winning or losing a case. It's about strategy, fairness, and ensuring that the legal system works efficiently. A brief note on motion practice. A motion is a formal request asking the court to issue an order. Some common examples include a motion to dismiss, asking the court to throw out the case before it even gets started, motions for summary judgment, arguing that no trial is needed because the facts are undisputed, or a motion for a new trial, seeking a do-over after a verdict. Motions aren't just about legal arguments, they're strategic. A well-timed motion can end a case early, saving time and money, force an opponent to reveal weaknesses, or increase pressure to settle. But motions can backfire too. Judges may get frustrated with lawyers who file unnecessary motions just to delay proceedings. Poorly prepared motions can also make a lawyer look unorganized, hurting their credibility in court. Every motion must follow strict rules, usually requiring written arguments, supporting evidence, and compliance with deadlines. Failing to follow these rules can lead to sanctions or even dismissal of the case. Now let's talk about remedies, the different ways courts can resolve a legal dispute. There are three main types of remedies. Declaratory relief. A court defines legal rights but doesn't award damages. For example, a company asks a judge to rule that a contract isn't valid before refusing to honor it. Specific relief. A court orders someone to take a specific action or stop doing something. Example, an injunction stopping a company from dumping pollution into a river. And damages. A court orders the losing party to pay money to the winner. Most civil cases end with monetary damages, but there are different kinds. Compensatory damages, to reimburse a plaintiff for actual losses. Punitive damages, to punish wrongdoing and deter others. Nominal damages, a small amount awarded when a legal wrong occurred, but no real harm was suffered. One key issue in civil litigation is cost. Winning a lawsuit doesn't always mean getting paid. Plaintiffs must enforce judgments, often by seizing assets or garnishing wages. And in the US, each side generally pays its own legal fees, meaning a plaintiff might win but still walk away with little after paying attorney's fees. Finally, let's discuss the rules that govern civil procedure. Where do procedural rules come from? Federal courts follow the Federal Rules of Civil Procedure, or FRCP, which were first enacted in 1938. The Supreme Court oversees these rules, and they apply equally to all federal cases, no matter how simple or complex. State courts have their own procedural rules, often modeled on federal rules, but increasingly diverging. Some states allow their courts to create procedural rules, while others require approval from the legislature. One big debate is whether one-size-fits-all rules make sense. Should the same rules apply to a billion-dollar antitrust lawsuit as a small personal injury case? Some argue that flexibility is needed, while others believe uniformity ensures fairness. Procedural rules are constantly evolving, especially with new technology like electronic filings, virtual hearings, and AI-driven legal tools. The COVID-19 pandemic forced courts to modernize, and many of those changes, like online dispute resolution, are here to stay. But there's always more ways to learn. Well, that's it for this episode. Stay tuned and we'll continue on to episode 2 with jurisdiction. We'll see you next time. Until then, always remember, when you need help, you can always count on Zech support.